watershed decision handed down in the Court of Appeal on Monday is final and will not stand in the Caribbean Court of Justice. Hear why in our first report.
Attorney General and Minister of Legal Affairs Senior Counsel Basil Williams said any attempt to approach the CCJ to overturn the decision of Guyana's appellate court in the Eslyn David versus the Guyana Elections Commission matter will not be heard. He said there is no appeal in respect of matters determined under Article 177(4) of the Constitution. The opposition PPP on Tuesday indicated that it has filed an appeal with the CCJ after a 2-1 majority decision Monday by Justices Brasington Reynolds and Dawn Gregory ruled that the Court of Appeal did have jurisdiction to hear the Eslyn David versus GCA matter and interpreted that valid votes cast also means more valid votes cast. Citing Article 177(4), the AG noted, quote, "The Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president insofar as that question depends upon the qualification of any person for election or the interpretation of this Constitution, and any decision of that court under this paragraph shall be final," unquote. While the CCJ accepts its position as a superior court of record, it has continuously recognized that it only possesses such jurisdiction and powers as are conferred on it by the agreement or by this Constitution or any law of the contracting party. In this regard, it does not usurp the jurisdiction reserved by the laws of the contracting party for the Court of Appeal of the contracting party.
Article 177(4) says quite clearly any decision made thereon was final, so that they couldn't appeal it. And equally, under our Caribbean Court of Appeal Act, Caribbean Court of Justice Act, Chapter 307, there's a provision also which says that the Caribbean Court will not exercise jurisdiction or hear any matter coming from our Court of Appeal, which was stated to be final also. So since this is final under 177(4), the CCJ wouldn't hear it.
The Act says nothing shall confer jurisdiction on the court to hear matters in relation to any decision of the Court of Appeal, which at the time of entry into force was declared to be final by any law. The Caribbean Court of Justice Act came into force in 2004. At that time, Article 177(4) of the Constitution was already part of the laws of Guyana. It made the decisions of the Court of Appeal final in respect of matters determined thereunder and expressly ousted the jurisdiction of any higher appellate court. For InfoHub, Alexis Rodney.